Доброго дня. Починаємо
Morning.
засідання.
So we shall start our meeting. PCIe members are taking part in the meeting. Names follow: Norman Oz and Mary Kay Butler joining us by video, and Gabriela Yotkaite. Testing.
Let's wait for a translation. I know which
English channel testing.
I thought you have already
English channel testing.
Ukrainian
Testing.
for this period. So maybe you can just go on.
1, 2, 3.
Okay.
1, 2, 3. Could you confirm if you can hear the interpreter?
Just go on.
Could you confirm that you can hear the interpreter?
You have. Okay. Mary Kay Butler, дистанційна Gabriela.
Mary Kay Butler, Gabriela Yotkaite joining us by video. HQCJ members are present. Names follow.
Пізніше буде Ярослав Дух, Роман Кадесюк.
We will also have Yaroslav Duch
Руслан Мельник, Олексій Амельян,
and
Андрій Пасічник, Роман Сабадаш, Руслан Сидорович, Сергій Чумак.
joining us later on.
Вже з'явився. Do you have translation? No?
Testing. English channel. English channel. English channel.
Okay. Let's wait for a minute.
English channel. 1, 2, 3. Testing.
Yes. Yes. Great. Наявний кворум.
We have quorum,
Оголошую засідання відкритим. Оголошую перелік
and
питань,
we shall open the meeting.
корупційного суду критеріям, передбаченим
The agenda is considering whether the candidates are compliant with the criteria of the competition according to the law of Ukraine on the status of the Hague Court, and the candidates' names follow. I have a proposal to make.
дещо черговість. Якщо не заперечуєте, Movchan Natalia Volodymyrivna перший раз.
Of the candidates, Movchan will be the first according to the agenda. Khodko
А замість Ходько, відповідно,
will be considered the last,
Михайла Рігера,
and instead of Khodko,
третє Смаль Інна,
we will consider Hrabinsky.
якщо не буде заперечень. Okay.
Brinsky will be number 2.
Yes.
Okay.
Okay. Yes. And Ходько will be the last one.
Got to go through it now. We'll listen to you, Robert.
Гаразд. Інших пропозицій немає. Прошу голосувати, враховуючи зміну таку черговості. Хто за? Одноголосно. Дякую. Отже, перелік питань затверджено. Переходимо до розгляду питання щодо відповідності кандидата на посаду судді Вищого антикорупційного суду Movchan Наталії Володимирівни. Прошу запросити її до залу. Зверніть, будь ласка, увагу. Знову у нас.
Please pay attention.
Yes. Is there?
Доброго дня.
Good morning.
Розглядається питання щодо
We
відповідності.
are considering issue of compliance of the candidate for the position of the judge of the High Anti-Corruption Court, Movchan Natalia Volodymyrivna, with the criteria set out by Part 4 of Article 8 of the Law of Ukraine on the Hague. We have present members of the PCIe, Robin Heimbrook-Heisen, Norman Oz, Mary Kay Butler, Gabriela Yotkaite remotely, John J. O'Sullivan, and Jessica Lott Thompson. Members of the HQCJ, Михайло Boganys, Людмила Волкова, Ярослав Дух, Надія Кубецька, Олег Колюш, Ігор Кушнір, Руслан Мельник, Олексій Амельян, Андрій Пасічник, Роман Сабадаш, Руслан Сидорович, Сергій Чумак. You have the right to request recusal, to submit motions, to provide explanations upon permission of the chair, to express considerations and objections. Do you have any recusal requests? I do not have any recusal requests. Okay, the rapporteur is Natalia Kubecka Nadia. Please, over to you.
So general information regarding the candidate Movchan Natalia Volodymyrivna. By the decision of the Commission, a competition to fill 23 vacancies at the High Court and the Appellate Chamber of the High Court was announced. The candidate Movchan Natalia Volodymyrivna approached the Commission within the deadline with her application to admit her to participation in the announced competition. She was admitted to the qualification test and participation in the competition by the decision of Commission of September 16, 2025. The qualification test for the candidates was announced by the decision of the Commission on September 19, 2025. A qualification test was scheduled and the order of its stages was determined as of September 19, 2025 by the decision of the Commission. The results of the first stage of the qualification test were announced on February 4, 2026. The candidate scored 335.65 points and was admitted to the second stage of the qualification test. In 2001, you graduated from the National University Law Academy of Ukraine, named after Yaroslav Mudry, and earned her specialist degree in law, as well as her attorney's qualification. Professional activities in law. From September 1997 to April 2001, you worked as specialist of second category, specialist of the first category of the specialized department of commercial disputes in the arbitrary court Kharkiv Oblast. From May 2001 to December 2009, worked as legal counselor, leading legal counselor, senior legal counselor, and the chief of the legal department at the joint stock enterprise bank Mercure. From December 2009 to June 2012, you worked as the main specialist and assistant judge at Kharkiv Appellate Administrative Court. By the presidential decree, as of May 2012, you were appointed at the judge's position at Ochtyrka City District Court of Sumy Oblast for 5 years. You took oath on May 2012. From June 2012 to May 2019, you worked at the judge's position at Ochtyrka City District Court, Sumy Oblast. And in June 2017, your 5-year term drew to a close. In February 2018, a qualification test was scheduled to determine the compliance with the position, including for your position, and based on the qualification test, you confirmed that you were compliant with the criteria of your position and authorized to administer justice. By the presidential decree, as of April 2019, you were appointed at the judge's position within the High Court, and until now, since May 2019, you have administered justice in the High Court. You have at least 5 years of judicial experience. You have submitted declarations on family ties, integrity declaration of a person authorized to perform the functions of the state or local self-governance. And within this competition, the Commission has sent requests to different state bodies and received answers.
Була надана базова інформація, можливо, бажаєте.
So this was basic information. Would you like to contribute anything? No contributions. Robert, over to you.
Good morning, Mr. Chair. Thank you for this. My name is Robert Broekhuizen, and I'm the rapporteur in your case. And there are three of us sitting here, but if you look at the screen, there's three others sitting somewhere behind the desk and a camera. And the lady on the left side on the screen, that's Mary. And I believe that with her it's 4:15 or something. So I hope you don't mind that she falls asleep. Are you awake, Mary? Okay, so we are ready to go.
Yes, sir. We're ready. Yes, thanks.
Fine. Quite an achievement, I must say, to be ready, to be awake at 4:15 in the morning. Tell me, I understand that there's a law in Ukraine that rules that you have to take your decisions always by yourself, and that you cannot use decisions that are written by someone else. Is that correct?
Так і є.
Yes, this is correct.
When I think about this, I'm wondering what your assistants do, because how many assistants do you have? One or two?
Two
And-
assistants.
But I guess that your assistant would make draft decisions, wouldn't it? Or would he or she?
Так, вона готує проекти рішень.
She prepares draft decisions.
And that is allowed according to Ukrainian law.
Так, це одна із функцій помічників.
Yes, this is one of the court assistant judges' functions.
But you would not be allowed to have your assistant, let's say your colleague, make a draft for you, because, for instance, your colleague knows more about a certain subject. Is that not allowed?
Відносно мене це неприйнятно.
So it is inadmissible in my case. Only myself and my assistants are involved in this.
But what I ask is whether it is allowed to have your colleague make a draft for you.
Я такого не знаю, що було дозволено.
I don't know of this. I don't know if this is allowed. So you started your question saying that every judge is independent in their activities. And therefore, it is up to the judge to make decisions, issue decisions, and organize the activities within his office or their office. If we take any other judge that consults with the colleague, a colleague prepares court decisions for them, I don't know of such facts.
But is that allowed in your view, or is that not allowed by law?
Думаю, що ні.
I think that it is not allowed. I'm actually convinced that it is not allowed.
Yeah, because I'm asking, because I find it strange, because my wife is a judge, a court of appeal judge in the Netherlands, and she's also a professor in civil law. And so sometimes if a colleague would not know enough about a certain subject, she would write something for the colleague to say, this is how you have to look at that. Would you not be doing that?
Це різні речі. Ухвалити
So these are two different things. Making a decision and discussing a subject that arises during a consideration of a case, these are two different things. Consulting, yes. Asking for a piece of advice, yes. But making a decision is up to the judge considering the case. This is how we interpret the law.
Okay, but my wife would be writing, let's say, part of the ruling. Would that not be allowed in Ukraine?
Давайте я буду за себе відповідати зараз.
let me let me answer regarding my activities. My husband is not a lawyer. The only thing that connects him to law is the fact that he's married to me. I always make decisions myself. I can ask for consultations from someone else, but when it comes to determining the parties, determining the issue, yes, I can ask for a piece of advice, but I make decisions myself. I haven't ever done it in my practice, writing a judge's decision with someone else.
Yeah, in my mind, that is strange because it would be if John would ask me, say, I have to take a decision and I know nothing about European law, which he doesn't, of course. And he would ask me to write part of his decision. I would help him and I would write it and say, maybe you have to do it this way, John. And then he would not follow me. So, very stubborn. He would write down himself what he thinks about it. But that doesn't mean that I cannot give it to him, can I?
Я ж і повідомляю про те, що порадитися стосовно певної обставини. Так.
So, of course, asking for advice, it is all right, but making it a court ruling, writing a court ruling, you need to do it yourself as a judge. So you consult, you sit down with a colleague, and then you make it yourself.
But then I don't understand why you have an assistant, because you said that your assistant prepares decisions. They do. So apparently that's someone else. They work for you maybe, but still they make the draft decision. Apparently that's allowed.
Рішення приймаються в два етапи.
So decisions are made in two stages. So I make a decision, but before there is a collegial work done, I inform my assistant of what needs to be put into the text, what needs to be described, and then I make a full version of the text based on what my assistant had prepared before.
Okay, but do I understand Ukrainian law then correctly that it says that you are not allowed to have someone else prepare a decision for you, except maybe your assistant? Is that correct?
Це так.
Yes, that's correct.
And the reason I'm asking, I think you know, there has been some articles in the news. Let me try to find it. In a publication of Slitsvo Info. Yes, you recall that, and there the writer alleges that you prepared the text of the resolution for another judge, for an ad hoc judge. And that was regarding the changing of a preventive measure for Oleg Shevchenko. I have no idea who it is, but apparently he's an important guy. And on the same case, you had 3 months earlier issued a resolution on the arrest in absentia of him. When I read it, I thought, yes, so what? But apparently, if I see your reaction, the question, you consider this very serious, that to be a very serious allegation. Is that correct? And I understand that you deny involvement in the drafting of this decision. That's also correct, huh? And can you tell me, did you have no communication with the judge who should draft this decision at all? And there was no contact between you and this other judge who should draft this decision? Or there was some contact?
Можна відповідати?
Could I reply already? Have you finished your question?
Отже, у цьому кримінальному провадженні
So in this criminal case, the investigating judge functions were performed by both myself and the judge mentioned in the article. If you read that article closely, then you will see that it says that my friend's wives sent her a file that I had authored. So I turned to that friend of mine in order to resolve that situation, and I highlighted the situation, giving a message on the interference with my activities, and I sent that to the High Council of Justice, and we established that the file allegedly authored by me was sent later. Then the full text of the decision was elaborated and published through the D3 under the law. I also consulted the lawyers from our court as to whether it is possible to change the name of the author, and this is very easy, technically speaking. So I do not confirm that information. I denied. I didn't help in drafting that decision in any means.
So explain me then how it was possible that your name appeared on the email address that contained such a draft decision.
Ну, не в електронній адресі, а зазначалось як автор
Well,
файлу.
it was stated as the name of the author of the file.
Я не знаю, але я чітко знаю, що
Uh,
цих підстав мені тричі було
I
заявлено.
know that for 3 times I had recusal because of that. And there were also attempts to obtain the access to my email. These were unauthorized attempts. And this is a part of criminal proceeding. I cannot assess it otherwise. There is a fact that the full text of the decision was published by my colleague through D3 much earlier than that file had been sent and created, and that is obvious to me.
So what you say is in fact that the metadata of a document, and that are the data that when you look, when you are in Word, you can see those when you click
Я думаю, що так.
start. Yes.
Я
That's something changed. Sorry.
Я думаю, що це так.
I'm confident that the entry data of the file had been doctored.
Why would someone do that?
Щоб була підстава відвести суддю.
In order to have a circumstance to recuse myself as a judge from consideration of a case.
In my file, there is also some data that you were having training, and that at the same moment that you adopted court decisions. Yes? And then the question is, how is that possible if you are having training? And how can you adopt decisions? How do you do that?
У 2020 році у нас
In 2020, in July, and I also had a training. I was an investigating judge back then, and I had some cases. And from the list that is stated in your request, 13 cases were considered by myself that day. I will point out that the first 6 cases are actually 3 cases which have a long text of the decision and then a short text of the decision. First, the short text is composed and then the long text is made and published. So this indeed, I considered these cases on July 6th, and I don't remember when our training started and ended, but I could have considered them before the 10 a.m. and after 6 p.m. Regarding other cases, these are decisions following the motions on investigative activities. They can be considered after 5 p.m. and this is a regular practice. So I think I organized my activities in a way that during the training, and back then all the trainings were done online in 2020, I organized my day the way that I could consider cases before and after the training. And I also provided you the records of the court records, but unfortunately they had been already destroyed for the expiration of terms. In 2022, I also had a similar case, and we also had a training for 5 full days. And in order not to suspend the court's activities, we made some changes to our agendas. And on February 2022, I was also in my workplace, and I also had a training. And to prove that the orders of who were supposed to get training when, I submitted all of that to you.
Yeah, of course, we have seen that, and thank you for that. I'm rediscussing this because everyone sees it. The question I have for you is that I understand what you say is that before your training started, you will have, let's say, considered those cases, or maybe afterwards. But those decisions contain of quite some text. Have you been typing the text yourself, or someone else was typing that? Was it your system? So how are you able to, on one day, when you have fixed amount of hours of training, to deliver all those decisions? It seems to be difficult because, yeah, if you do that before 10 o'clock, you have to start very early, or you're not listening to the online training. It's also possible. Or someone else prepared them. How did it go? How did you do this?
Я звернула увагу на те, що в той період я виконувала функцію.
I said that back then I was the investigating judge, and in my diary 2020 I had 7 to 8 cases. Out of those I considered one was scheduled for 10 a.m., the other scheduled for 10:30. I rescheduled it for 4 p.m. And then the later one for 4:30. Then those cases pertain to cancellation of the property arrest. And the judge in the first stage can only announce the first part of the decision, and the full text of the decision can be published within 5 days, which I did.
Okay, thank you. When you applied for the present competition, you attached a declaration of integrity of a judgeship candidate for 2024. That's correct, huh? And yes, and
yes.
You noted in this declaration of integrity that you're not aware that your family members have visited the territory of the Russian Federation after the 1st of January 2015. Is that correct? But the point is that we noted that you yourself traveled after that date. So that means that your declaration in 2024 is not correct.
Mm-hmm.
Is what I see correct, or did I make a mistake there?
Значить, відповідно до правил заповнення декларації.
According to the rules of filling out the integrity declaration and declaration of family ties, the family members are those that I indicate in the declaration that I submit to NACP.
That's not what I asked. What I asked is about yourself.
Це те. Стосовно мене, не близьких осіб. Стосовно мене. Отже, заповнюючи декларацію доброчесності.
So when filling out the integrity declaration for 2023-2024, I confirmed that I did not visit the territory of the Russian Federation or the temporary occupied territory because according to clause 4 of the rules of the filling out this declaration, I needed to indicate that in 2023-2024 I didn't go to the Russian Federation. When I filled out my declaration as a candidate to the judge's position, the statement there was different. It said, do you confirm that you didn't visit the territory of the Russian Federation temporary occupied territory from January 1st, 2015? So in those declarations, I indicated that I had 1 day of visiting that territory.
Did you note in the declaration, did you note down in the declaration that you visited Russia after 2015? You did.
Один день.
Yes, I did. I did indicate that. 1 day.
Okay. Okay. And then you were also asked about your family members. There the answer was, if I'm not mistaken, that your family members did not visit Russia after the 1st January 2015. And when I listened to you, your explanation is that you did not need to specify your family members like your father, your son, etc. in this form. Is that correct?
У декларації ставиться питання про виїзд.
So in declaration, it asks whether my family members visited the territory of the Russian Federation. According to the law, family members are determined on the basis of the anti-corruption law. And the ones I indicate in my declarations are the ones I indicate in my declarations. My family members are those that I indicate. The members of the tight-knit family, a core nuclear family, not the distant family members.
But yeah, of course, I'm only a guy from the Netherlands. I don't know how declarations work. But I see that your son made 2 trips. I think your husband made few trips. So.
Син їздив двічі.
My son made 2 trips. My mom and dad went there, and my brother went there.
And your brother. Okay, that's it. And your mother and your father quite a few trips, quite a lot. And your brother also quite a lot of trips. And then I'm wondering whether it should not have been wise to fill in this form more complete. Because you say, well, the law provides that I have no obligation to do this. But then you have a discussion like this. It looks as if you don't fully present the full facts, your declaration. Or is that so? Not follow what I said. Would it not have been wiser to put all this information in your declaration?
Я виконую вимоги та
I fulfill requirements according to the requirements of the law. And I've mentioned by which legislation I was governed, and the way the statement was formed, that's how I answered. When it is necessary to inform about close relatives, I have no problem with that. I can tell anything that the respective body is interested in, or any other person. But in case of declaration, there are clear requirements that I have to adhere to.
Okay. So what you say is the law didn't provide that I should declare those trips, and therefore I didn't. Can you explain why your family members made all those trips to Russia?
Так, у 2012
Yes,
році
in 2012, my nephew entered the university on the territory of the Russian Federation, and he was studying there until 2015. That's why in 2014, 2015, as you can see, my mom and dad were frequently visiting our student there. They were visiting him. In 2015, in connection with the fact that in 2014 the aggression started and the territory of Ukraine was temporarily occupied, my nephew continued studying on the territory of Ukraine. But he came not on his own, he came together with his fiancée. And from 2015 to 2017, they lived on the territory of Ukraine. My nephew was studying and they lived there. On the territory of Ukraine, they got married. In 2017, his wife got pregnant and she decided to give birth close to her parents. That's why she, in 2017, and as you can see, in 2015 to 2017, none of my close persons crossed the border of Ukraine. In 2017, they left to give birth to a child close to my nephew's wife's parents. On the 28th of November of 2017, their kid was born, and that's why my close persons started going there in order to communicate, visit them, and to support these family ties. And that was the reason for these trips. And this way, my mom and dad visited their great grandson. My brother was visiting his grandson, and my son was making 2 trips after the birth, and also in February of 2018 for christening of the child. So all the trips were one-day trips. No one stayed there. And given the question raised by the civil society organization that I could see in my dossier, they did not stay in any hotels. They did not go to any supermarkets and stores to pay for anything and this way to finance the armed aggression. No, never. They left in the morning and they returned to Kharkiv in the evening. That's it. They just met at the place of residence of my nephew.
Yeah, when I see this, I without any judgment, I think that it shows that the connection to family members in Russia is quite strong. And then, of course, the worry would be that that your family has relations with Russia. That's, of course, the reason it is asked. How can we be sure that those relations do not exist?
Я розумію, що складається.
I understand that there might be such an impression, but I can assure you that for the purpose of those trips, and it was purely about family ties. Back then, our family was big, it was friendly, and we continued communicating, especially given that back then we still had hope that they would come back to Ukraine with their child and that they would continue living here, but the situation happened as it happened. And unfortunately, within the family, I have no relation to the family, I have no influence there, and my decision is not decisive, and my kids did not leave the territory of Ukraine.
These were my questions. In fact, I'm just looking at Mary is still awake, I see. John? No? Yeah. Back to you, Mr. Chair.
Дякую.
Thank you.
Пані Надія.
Madam Nadia, over to you.
Відмічую, що в засіданні бере участь член комісії.
I would like to point out that Hatsaluk has joined the commission. Madam Natalia, probably we will continue discussing more specifically those questions that were raised by Mr. Robert, and I will ask also some new questions. With respect to the new questions, I don't know whether you had a chance to process, because I see that you received the After Maidan's address on Friday. And again, we are talking about adoption of decisions in 2020. And After Maidan is talking about adoption of court decisions during sick leaves and annual leaves. That's 2013, 2015. Can you inform us anything about those dates? Have you had a chance to look through that information? Because I understand that it was 2013. Unfortunately, I could not process that information, but just I would like to emphasize that that was the first day, for example, 2013, 2015, the first day of being on the sick leave. In the morning, I could be at work, and in the afternoon, I could go to a doctor. So that's not... that's possible. With respect to annual leave, it's not very clear to me, because I'm very reasonable in my approach to that. And maybe unfortunately, I didn't have a chance to clarify anything. Maybe you were revoked for that one date, because there are 13 court decisions for one day. That's a full working day. Yes, maybe. You're talking about 2013 and 2015? Yes, yes. 2015, that's indeed the first days of the sick leave, and as you've explained, there could have been that situation. Now, with respect to the trip to Russia and your integrity declaration, let's discuss this question again. So, in your integrity declaration of the candidates, you mentioned and you provided additional explanation that you were on the territory of the Russian Federation. As established, it was one day. At 9 a.m., you left for Russia, and then in the afternoon, you came back. After that, you did not enter the territory of Russia, according to information that we have received, and that you're confirming. That yes, I confirm that. Now, about family members, in your explanations, you said that you know that your family members did not visit the territory of the Russian Federation after the 1st of January of 2015. And at the first glance, it really looks strange that you're confirming that, in particular, your son left abroad. But as I've understood, you were governed by the explanations of the Commission, where it is said that family members are those persons who are declared according to the law on the corruption prevention. And for the last time, you declared your son as family member in the declaration for 2015? I've checked. Yes, yes. In 2016, he was no longer declared. So he stopped living with you, right? He was an adult in 2016. Yes. So formally, based on these formal grounds, you declare that actually your family members did not visit the territory of Russia. And your family members included only your husband, your son. Yes, yes. But since he was an adult and you did not declare him in the declaration, that based on this motivation, you provided this statement. Not only based on that motivation, back then we lived separately. I was a judge in Okhtyrsky City District Court for the entire week. I lived in Okhtyrka, and I went home to Kharkiv only for the weekend. My husband and my younger daughter lived at the address, and I was supposed to declare them. But my son, for some period of time, he lived separately. And I declared the right to use an apartment. And my husband and my daughter lived in the apartment of my parents, and my son lived in our apartment that is owned by my family. So we did not have common residence or household. Okay, understood. Your position is clear. With respect to that publication by Slistvo Info, with respect to the draft decision, as you've just explained in detail, you are denying that, you are saying that you submitted an application on interference with the administration of judges to the HCJ, among other things. Can you please explain how did you justify that interference and what was the result? I addressed regarding the interference in another criminal proceeding, not in this one, where the decision mentioned by 6.4 was mentioned. That's a completely different one. There, I provided the list of circumstances that happened when I was an investigative judge. Out of 17 hearings, there were 11 motions on recusal. That's another case, right? That's a different criminal proceeding, where the recusal was satisfied. The matter is that the proceeding is different. 1 second, Madam Natalia. So let's come back to the question related to this draft decision that allegedly was drafted by you. How did you respond to this fact? You said that you were not preparing that draft decision. What was your response to somehow refute that? No, I did not respond in any way to it. Apart from including that into the notification on interference, there was no other response from me. Now, actually, about this second fact, now you will provide us more detailed explanations about that. We received information from Aftermaidan, and we are seeing there this information about this ruling on your recusal. That's a completely different case. Yes, that's the third case. Okay. Here it was said that that recusal that was requested by an attorney, and one of the circumstances in this motion is that the attorney submitted a motion on temporary access to items and documents in which to provide temporary access to materials, and with a court ruling dated April of 2025, the panel of judges, including you, denied in satisfying that motion, and the ground was that, and as far as I understand, another attorney who worked in the same law firm with the other defense attorney representing that person has already received access to the materials of the pretrial investigation. And in the ruling, your colleague, while responding to that motion, said that indeed the material of the recusal request did not contain information that the presiding judge committed actions in order to ensure that the defense attorney had a chance to look through the materials of the criminal proceeding, which could impact the exercise of the right for the defense of the defendant. And besides, in the ruling, it is said that in view of the above, the judge believes that the refusal request of the attorney did not specify circumstances that would demonstrate the biased attitude of the judge, but given the doubts of the defense counsel about the impartiality of the judge is reaching the conclusion that it is necessary to satisfy the motion on the recusal of the judge. With respect to this failure to ensure right to defense and that recusal, I would like to add, what was the peculiarity of this criminal proceeding? The preparatory court hearing was held by the panel of judges. I was the presiding judge, and we had also two other members of the panel. The decision on temporary access to materials of the criminal proceeding was considered by the panel of judges, and the final decision upon the results of the preparatory hearing, we motivated that. The further consideration of the criminal proceeding was supposed to be considered by me individually, according to the requirements of the CPC. I received two recusal requests, and they were allocated to two judges of our court. One judge satisfied this recusal request, and the other judge denied and satisfying based on the same grounds. And even the Aftermaidan finds some contradictions in that, but according to the Code of Judicial Ethics, according to the Bangalore rules, I have no right to provide my assessment of the colleague's ruling. If that were ruling were challenged, then I would have provided all of my opinions regarding that.
Стосовно повідомлення про втручання,
With respect to the notification on interferences, I did not submit that. Why? Because my previous notification on similar crowds where I had lots of recusal requests, my issue was resolved by the HCJ for 9 months. And the HCJ reached the conclusion that all of these issues should be resolved following the procedure stipulated by the CPC. Okay, understood. So for some reason, I thought that that notification on interference was about that case, but it was about this similar case. Yes. And the HCJ did not find grounds for recognizing interference. I do not have any more questions. Thank you. Colleagues, do you have any questions, please? Good morning. I have a follow-up question, after all, about this sending of the file. It's not about this instance. As a rule, in the staff, there is a practice of sending samples of reasonings. Do you have such a practice in your court? We do not have that, and I will explain why. Motions within... No, you do not understand. No, I understand. Every investigative judge has prepared that practice from themselves. That motion within the framework of this criminal proceeding was not the first one for Andrei Volodymyrovich. So even the reasoning in part, you didn't have to take it from anyone. No, I just mean if you are sending the sample of your reasoning from another case without the materials, then when you are sharing that file, you remain the author, even if it's rewritten and changed. So the author of the file can either be created by you or it could have been based on some samples or explanations that you could have shared. But you said that you didn't share anything. Okay, thank you. I'm sorry, but the author can be my assistant as well. No, any computer on which the authorized user is under your login. Once again, under my login, apart from me, no one is working. Trust me, the key is always with me. That's not that instant. No, I'm not about the login. I'm about the Word document shared with anyone. When you're sharing the document created on your computer, for example, when you're sharing a paragraph from your reasoning pod, or when you're sharing some typical phrases, by sending that document, no matter who edited it, you still remain the author. It does not mean that you were the author of the procedural documents. Maybe you were writing or typing some part. I'm not saying that someone was logging into your computer. Unfortunately, you're seeing... No, let me explain that. In response to Robert's question and your question, when we're discussing some issues, it's like a judge might say, here, in this case, under this case, I decided like that. Yes, and to share. No, wait. And in my dossier, there is a list when I had full access to the register to look for specific cases. This turning, that's where I'm the investigative judge, but other investigative judges are also taking other decisions. And no one needs to share anything because everyone has the access to this unified register of court decision. I understand, but my question was another. Okay. No, I did not send anything to anyone. Okay, colleagues, do you have any other questions? Madam Natalia, I will continue if possible. We are not even talking about the fact that judge is sending something to another judge. As you clarified with Mr. Robert, drafts are prepared by assistants. It's an obvious situation. It's well known in Ukraine to everyone that assistants talk to each other and they ask each other, do you have something similar? Oh, give me some sample, please. It's not necessarily this sharing of documents between you that could be correspondence between assistants. But if you created that file and the assistant shared it with another assistant, then you will still remain the author of this Word document. And even if the assistant of another judge is editing that document, it will just like recently at last edited by someone. But the owner of this document is you. Well, you know, Here, no matter how you ask this question, that file was shared by the wife of the husband. How the wife got this file, which assistants were communicating, that's difficult for me to answer that. That was not among judges, you know? Not, yes, I understand you very well. And somehow like that even. Wife was sending the husband and the file was authored by me. And for me, that looked strange. Okay, thank you. Colleagues, do you have any other questions? No more questions? Mr. Robert, maybe you have new questions now.
No, thank you, Mr. Chair. Thank you for your answering.
Добре. Дякую. Так. Ну, у нас
Okay, thank you. I see that online we have no questions either. So, okay, thank you. Madam Natalia, you have a chance to address the PCIe and JSQJ members. Maybe you would like to add anything. Please, over to you. What to add? I've mentioned the key in my response to request where this motivation about my reasons for applying for this competition. And I said that I consciously selected the job of a professional judge. And my conduct, how I perform my functions, show a lot about my attitude towards my position and my service. Position as the judge of the High Anti-Corruption Court has added even more responsibility and requirements to myself and to everyone who is working with me. Thank you for the interview, and I wish a reasonable, balanced decision. Thank you. Goodbye. Goodbye. Thank you for the interview. Goodbye. Now I'm announcing the interview over, and I'm announcing a technical break.